RFB Legal, the Private Wealth Series.
Hi, my name's Kate Farkins and I'm a trainee solicitor in the private client department here at Ronald Fletcher Baker Solicitors. The purpose of this video is to explain the basics of a will, why it's important to put one in place, and how Ronald Fletcher Baker can help you do this. Wills are really important documents. They allow you to direct who your estate goes to once you pass away. Without a will, the rules of intestacy apply. These rules dictate who your estate would pass to after you've gone. For example, if you have a spouse or civil partner and no children, everything would pass to your spouse. If you have a spouse or civil partner and children, all of your chattels, the first £270,000, would go to your spouse, and the remainder of your estate would be split in half, with 50% going to your spouse and the remaining 50% going between your children. If you have more than one child, it will be split between them equally, and if your child predeceases you but leaves children of their own, their children will inherit in their place. If you have no spouse, civil partner or children, your estate is left to surviving family members in a priority order. First priority is parents, then brothers and sisters, then grandparents, and then uncles and aunts. So it is sensible to get a will in place to be in control and so that you're not relying on these rules. Some reasons why people get wills is the ability to appoint executors. Even if you wish your assets to pass in the same or similar way as they would pass under the intestacy rules, these people may not be best placed to administer your estate. So you can appoint who you wish to be executors in your will. It doesn't have to be family, and it could be a friend or even a law firm. Also, if you have children under 18, you can appoint guardians who will take care of your children after you've gone. If you've separated from a spouse or civil partner, but it's not been formalised by divorce or dissolution, they would stand to inherit under the intestacy rules, as in the eyes of the law they are still your spouse. So in this case, it would be important to put a will in place. It's also important to bear in mind how a property is held. If you own a property as joint tenants with a spouse or anyone else, if you were to pass away, your share of the property would pass to that other owner, irrespective of what is in the terms of your will. If that's the case, you would need to sever the tenancy so it's held as what we call tenants in common, so you can leave your share of the property when you pass to whoever you like under the terms of your will. Another point why you might want to get a will is you want to leave a gift to a charity on your death. You can do this by specifying the amount you want to leave to a charity in the terms of your will, and all gifts to charity are free from inheritance tax. It's also important, if you already have a will, to get it out and review it every so often, just to ensure that it reflects your wishes. Often things have been incorporated into wills previously, which were done specifically for the inheritance tax regime at the time, and they may no longer be applicable. As your situation and the law around inheritance tax changes, your will may no longer be tax efficient. Also, if you're planning on getting married or entering into a civil partnership, or you have recently got married, your will may be invalid, so you will need to check your will and it may need to be redone. In terms of the basics of a will, you are able to appoint an executor. This can be anyone, and it's usually family members. It can be a friend or even a law firm if you wanted to. These people are responsible for dealing with the administration of your estate. You can have up to 4 executors, but it's usual for people to have 2, although you can only have 1. A will may be contested after you've passed, so in these situations it's often beneficial to appoint someone who's completely independent. Then you can have the option of leaving specific gifts of items or money to certain people or charities in your will, or in a separate letter of wishes, and these can either be subject to or free from inheritance tax. The payment of inheritance tax, funeral expenses, legal and administration fees have been made from the remainder of the estate. You then have your residuary estate left. This can be left to whoever you want in however many different shares that you like. It's usual for people to leave their residuary estate to their children. Another common thing is that if you are married or in a civil partnership, that the first person to die leaves their entire estate to the other spouse, and then on that second death, the estate gets split up between family. This makes it much simpler to deal with the estate when the first spouse passes away, and it also takes fuller benefit of the spousal tax exemption. The next point is executing a will. This needs to be executed by yourself with a wet signature in front of 2 independent witnesses. It's best for these witnesses to be entirely independent if possible and not an executor, although they can be if that is the only option available to you. However, it's really important to note that witnesses cannot be a beneficiary or be married to a beneficiary. If a beneficiary or their spouse witnesses a will, they are effectively disclaiming any gift left to them in that will. Due to coronavirus at the moment, it's made it quite difficult for people to prepare wills and get them signed. At Ronald Fletcher Baker, we're extremely adaptable to the times. We put a process in place to make this as simple as possible for you. First, we'll provide you with an initial will questionnaire, and you can fill this out in your own time and send it back to us. We'll then review it and organise a video call where we can discuss the contents of the questionnaire and the provisions of your will. We'll then draft up a will for you to review. Once you're happy with this, then we can finalise the will, and we can either email it for you to print off at home, or if you're unable to print it off at home, we can always post you a copy. Then you can either arrange for it to be signed and witnessed yourself at home. Perhaps if members of your own household aren't beneficiaries in the will, then they can witness the will, or neighbours over a garden fence. We would request that we would be on a video call when this is being done, just so as far as possible we can see that it's being done correctly. Alternatively, if possible, we can witness your will. So either 1 or 2 of us, depending how many witnesses you need, can come to you and witness the signing of your will from a safe distance, either in the front garden or through a window. We can either store your will here at the office for the remainder of your lifetime, or alternatively you can keep the will yourselves. All wills that we store are also registered on Certainty, the National Will Register, for free. If you'd like to discuss anything in this video or discuss putting a will in place, then please contact us at probate@rfblegal.co.uk and we'll be happy to help you. Thank you.